This morning, the court is going to deal with two items. The first one is a date of postponement of the case, and the second one is an application for bail for the accused, a bail application for the accused. The first item does not seem to be an issue. I called both counsel to my chamber to discuss the way forward with them and to obtain consensus, and we seem to agree that we should postpone this case to the 9th and the 10th of March next year. Is that so? You confirm? Yeah, the 9th and the 10th of March next year. Yeah. The 9th and the 10th of March are too far. But it seems that we have no other way except to set it down for those dates. I see now why we've got to start with that, with the date of set down, that is the 9th and the 10th, before we can come to the other item, because the postponement date has a bearing on the application for bail, I think. So I shall note here in the bench book that this case is hereby postponed to the 9th and the 10th of March 2016. On those days, 9th and March 2016, the court will hear argument in mitigation and aggravation. And I have to emphasize to both counsel to make sure that they prepare themselves for that date, because no other postponement can be granted after the date. The 9th and the 10th of March definitely will hear argument in mitigation and in aggravation. Mr. Makubela, if you're going to file heads or call witnesses to testify, please make sure that you've consulted with them before those dates, and you must be ready for the 9th and the 10th. And these are instructions from the JP as well, because we cannot keep on postponing this date further. The second item then has to do with a bail application, and I'll hear argument on that, because I'm told by counsel for the state that the state is opposing the application. I don't know on what grounds. I'll hear argument this morning on that. Mr. Makubela, do you want to have a right to begin on the second item, on the application for bail?
Yes, I wait for what will be as follows. That we will not be leading any oral evidence. I will proceed by way of affidavit, after which, if necessary, will address His Lordship on specific aspects, and or matters that His Lordship would want me to specifically deal with for purposes of the application. And as a point of departure, I wish to submit, before I read the affidavit into record, as it will also be later argued, that this application should and ought to be seen as one falling within the ambit of the so-called Schedule 5 bail application for the following reasons. Namely, that the initial charge against the accused, and when she applied for bail, it had in fact been a common cause factor, and also in the light of the charges that have been preferred against the applicant, it appears that it falls within the purview of Schedule 5 bail instances, as also in the light of Your Lordship's finding in Your Lordship's verdict of guilty on murder. I am going to show and demonstrate through the affidavit that in fact this is a matter that falls within the ambit of Schedule 7, and to that extent we anticipate that we will be expected to show on a balance of probabilities that it is in fact, and it would be in the interest of justice, to show factors' existence that would allow the bail to be fixed in favor of the applicant, as opposed to the so-called Schedule 6, where exceptional circumstances are a requirement. I do not know if it is common cause with my learned friend, and whether I should start immediately with my affidavit, or whether His Lordship wishes to make a ruling in that regard.
Do you have an original copy of the affidavit to hand up to court?
Signed that I am going to go through with His Lordship for the purposes of expediency, but at this stage I am seeking with respect His Lordship's guidance as to the matters that I have raised, namely whether it's common cause or otherwise, that as I submit, that this appears to be one of those instances that should be characterized and categorized as a Schedule 5 bail application.
Yeah, before I give a ruling on that, if I have to, have you given a copy of the affidavit to counsel for the state?
Indeed, my Lord, as is expected of counsel.
When is the court going to have a copy of the original affidavit?
Immediately I get the green light to proceed to do so, my Lord.
Right. Mr. Skete, do you have anything to say to this?
Yes, my Lord, the question whether this matter falls under Schedule 6 or 5. Schedule 6 determines if it's a premeditated or planned murder. Schedule 5, if it's a murder not falling under Schedule 6. My Lord, in the light of the court's finding being the bounds of self-defense that has been exceeded, my Lord, it's submitted that this matter in all probability falls within Schedule 5, and therefore the state is prepared to proceed on that basis that this matter indeed falls under Schedule 5 of the Criminal Procedure Act, my Lord.
Right. As it may please.
It is obvious that it's a Schedule 5 matter, and you may proceed. Please proceed.
My Lord, also wish to bring the following into the matters at hand, namely that I am going to ask that the pre-trial bail application affidavit be also taken into consideration, and it consisted of an affidavit and facts, and it is Exhibit F. And the affidavit that I intend to proceed with should be read and understood to incorporate those factors, as it were.
I don't have the file here. Can you give the exhibit file? Oh, here is it. Yes, exhibit F. Right, proceed, please.
In the High Court of South Africa, Gauteng Local Division, Johannesburg, sitting at the Randburg Magistrates Court, case number SS52/15, in the matter between Manqele Sindisiwe Precious, the applicant, and the state, who are the respondent. Affidavit in support of application for bail pending the sentencing proceedings and sentence. I, Sindisiwe Manqele, state as follows. The contents hereof fall within my personal knowledge except where otherwise stated, and are to the best of my knowledge true and correct. I am the applicant in the matter. I make this statement in support of the application for bail to be reinstated or set in my favor pending the sentencing proceedings and sentence by the Honorable Court. On the 9th of December 2015, which is yesterday, the Honorable Court, having convicted me of murder as originally charged, ordered that I be forthwith kept in custody as my bail privilege is lapsed pending the finalization of the matter. I am advised, which advice I accept to be correct, that in the light of the nature of the charge I have been convicted of and further await to be sentenced, this bail application falls within the purview of the so-called Schedule 5 bail instances. I further appreciate that it shall be incumbent upon me to show on a balance of probabilities that there are factors and or circumstances present, the existence of which justifying my further release on bail in the interest of justice. I further appreciate that the constitutionally entrenched presumption of innocence that is usually operative is somewhat inhibited to can effectively weigh in my favor, since I have now been convicted and stand to be sentenced. In the meantime, I have instructed my legal team to secure the transcripts of the Honorable Court's judgment and findings in the trial, which information is required by the expert witnesses that are intended to be called on my behalf in mitigation of sentence. I am advised that the witnesses include, but not limited to, a probation officer, correctional supervision officer, psychologist, and other relevant witnesses as it may be relevant in mitigation of sentence after due consultations with my attorney of record. I am advised that the turnaround time for the processes and procedures that I will now engage and set into motion to assert my constitutionally entrenched remedies as enunciated above is normally a long and substantial period. Taking into account that not much can be done this year because of year-end related rounding off of most businesses, I, however, submit with respect that the course adopted by my legal representative in this regard is necessary, since it will be in the interest of justice to do so. At the inception of this matter, I remained in custody until a formal bail application was held and subsequently determined that I was not a flight risk, nor a danger to the public, and that the interest of justice favored my release on bail despite the serious nature of the charge. I was granted bail at the sum of 10,000 rands plus further conditions to report at Midrand SAPS on stipulated days and conditions. No finding that any other interest of justice stood to be prejudiced by my release on bail was made at the time. I religiously adhered to the conditions and attended court throughout whilst on bail until the Honorable Court convicted me of the offence. There was no occasion I did not attend court, as this Honorable Court remains better placed to know from the record of proceedings in this matter. I hasten to add with respect that even after the passing away of my father about 4 weeks ago, I still kept to the conditions of reporting to the SAPS during the difficult time, which included the eve of his burial. Despite the probability of an adverse finding accompanied by the probability of a severe sanction in the light of the charge that was preferred against me, I remained in attendance because I have an informed confidence in the judicial system of the Republic of South Africa. Except for the existence of the present conviction and the now to be imposed sentence, very little has changed other than to the extent that I have and continue to indicate to the court insofar as my personal circumstances as was submitted during my pre-trial formal bail application. My physical health remains good, but since the incident that has now resulted to my conviction, I have been receiving counseling, and the recent passing away of my father has not made it easy for me. I have since been on and off tranquilizers under the supervision of a family doctor. The prison hospital seems to be ill-equipped to deal with and or handle my situation stroke illness as a trial awaiting prisoner. This I state with respect from my previous experience there before I was released on bail. South Africa, and more specifically Gauteng in Kempton Park, remains my home, and I have no intention to depart therefrom, as everything that I owe my life to and own is rooted there. I am the only child of my late parents and stand to inherit, in terms of the interstate law, the house and its contents, the values of which I believe to be substantial. I am yet to conclude the cleansing rituals and ceremonies related to the mourning period related to my father's passing away about 4 weeks ago. I submit with respect that I have shown myself to be a person that believes in exploiting and exhausting the legal processes and legal woes than to resort to being a fugitive from justice. I am advised that the test that the Honorable Court will apply in order to evaluate the merits or demerits of my application remains, I quote, whether there exist facts on the basis of which it has been shown on a balance of probability that the interest of justice permit my further release on bail pending finalization of the matter, close quote. I am further advised that the main thrust of the Honorable Court's verdict of guilty was that although I acted in private defense, as apparent from my plea, I seemingly exceeded the boundaries thereof as opposed to a determination of premeditated conduct. I accept this advice to be correct and remain confident that despite the possibility of the minimum sentence of 15 years imprisonment being imposed, the existence of factors to persuade the Honorable Court to deviate and impose a far lesser sentence will be proven, including the possibility of a non-custodial sentence and or community-based correctional supervision. I humbly submit that any hurdles to deny me bail pending the sentence process have been adequately addressed. The imposition of further stringent conditions to minimize the risk of non-compliance should also militate against any refusal to grant me bail in the present circumstances. I also respectfully submit that a refusal to grant me bail at this stage will or may render my right to consult and place mitigating factors before the Honorable Court nugatory. I therefore humbly submit that this Honorable Court ought rightly to remain persuaded that in the overall and accumulatively, the existence of the relevant factors and or circumstances is established, that therefore it will be in the interest of justice that I am granted bail pending the outcome of it is a typo error, the outcome of the process, and I wish to delete the letter appeal, as it were, for the purposes of this affidavit. And it is signed Sindisiwe Manqele this day, the 10th of December 2015. And as it may please the court, I beg leave to hand it in as an exhibit for purposes of the bail application.
Yeah, the word appeal process in the last
yes.
sentence, just substitute the word appeal with the word sentencing process.
As it may please the court, my lord.
Now, the exhibit will become exhibit what? J. This document, which you have just read out to the court, is hereby accepted by the court as exhibit J.
As it may please the court. As indicated to His Lordship, we will not be needing any further evidence.
Yeah, but you see, you seem to forget that you indicated to the court, even in this affidavit, that this affidavit will incorporate the one of the bail application, and you haven't referred to any sentence in the bail application.
The factors that I requested to be incorporated to other personal circumstances as they stood, and said that they haven't changed, and to the extent that she remains unemployed, that she was a student whose studies have been suspended because of this particular matter still remains, my lord.
They have changed. Her father has passed away.
Yes, and as I said, to the extent that I will indicate, and I have indicated it in the Exhibit J that is lying before his lordship now.
She's no longer having the same personal circumstances as at the time when she applied for bail.
Yes, to the extent that is indicated in the affidavit, my lord.
Maybe I should ask a question later. I was about to ask the question, who is the executor or executrix of her late father's estate?
The matter is still fresh, and she has a lot to deal with at this particular stage of time, but she is the only heir, and it would appear the attorneys are dealing with that aspect, but she is definitely the heir. But I am not certain as to whether as an heir you can at the same time be an executor. I don't have any instructions to
Instructions on that. Okay.
What is aware is that at least she can now say without the fear of contradiction, state before his lordship that she has property or a fixed property in the form of her father's house or her parents' house, as opposed. Yes, indeed, my lord, and I repeat with respect to the extent that I have and it has been indicated in the affidavit.
Right, Mr. Skete, you say the state is opposing the bail application.
Indeed, my lord, the state do not intend to lead any evidence in this regard and will be argued on the facts before this court, my lord.
You're not going to, you haven't prepared an affidavit or anything of the sort?
No, my lord, it will be argued on the evidence that is before this court.
Now, Mr. Makubela, having submitted Exhibit F to the court and having read it out into the record, it is therefore not necessary to call the accused into the witness box to testify on anything, isn't it?
As it may please the court, my lord.
The status of the affidavit is sufficient. Do you want to make any further submissions? Counsel for the state says this will be argued on the facts before the court.
And I can, with respect, assume that my learned colleague is going to latch on the aspect that the only reason why bail is being opposed is the fact that the applicant now is a convicted person. And if my assumption is correct, I submit with respect that despite the conviction, but the sanction from the onset had always been pending, and despite its pending nature, having been on bail throughout, she never deviated and religiously, as stated here, adhered to the conditions. And indeed, that is reason for apprehension that she is now a convicted person. That can be militated by imposition of stringent further conditions. Amongst others, I submit with respect reporting on extra time, extra days, and or even including a monitoring bracelet, and also despite her financial constraints as it were, if his lordship is of the view that 10,000 is not sufficient, by upping it to the extent that the court deems it necessary. Unfortunately, my lord, the accused has not taken transfer of the property to the extent, as in other cases, that she can actually pledge it as her bail. She still remains a person of straw, as I now address his lordship, despite the potential that there is there, and I can submit to his lordship that she is indeed the only heir to what is left by her late father. And the amount that she is able to can even scrape around with her cousins that are present, I am instructed, is up to an amount of 5,000 rands on top of the 10,000 rands that there is before for bail, my lord.
I do not know the conditions which were set against her to obtain her bail, her previous bail.
My lord, were two, namely to report on every Monday and Friday of the week at the Midrand police station. Between specific times of the day, before 5 o'clock, before 6 o'clock. I'm sorry. And she has an option, if the court is persuaded, to can also report, which is far more nearer than Midrand, to report at Kempton Park at her parental home. The motivation for the previous reporting at Midrand police station when the bail was fixed was at that time because of the hype surrounding her release, and we requested that she stays at an alternative address which was closer to Midrand. But as we speak now, and we have no safety concerns for the applicant, that she is back home to a parental home, because there are other things that she needs to do related to the cleansing and rituals to close and wind up their father's late estate.
Yeah, you say there were two conditions. Firstly was reporting on Mondays and Fridays. And the second one?
Before 6 o'clock of each one of those days. The second one, to remain in attendance in court until excused by the court, the ordinary bail condition.
What I want to know is...
She also surrendered her passport, which is still with the state, my lord.
What else?
Yes, those are the only three conditions.
Are they specified somewhere in a document?
The document at which she reported at the police station, I do not have that document, but it is common cause between the state and the defense that those were in fact the conditions. And his lordship would remember, with respect, that during the trial, his lordship would each time remind her that even on this Friday or even on Monday, even after court is a Monday, and they are basically the same code, but they are common cause. They have been there, my lord, of Monday and Friday. I do not anticipate that my learned friend will contradict that. The investigation officer is in any event, with respect, also present to can also assist the honorable court insofar as information to that regard.
I gained an impression that as far as reporting to a police station at Midrand, the condition was stricter than reporting on 2 days. And you recall I was approached to relax that a little bit, and I said from now on you report only on Mondays and Fridays, and she's religiously stuck to that. And each time I would ask her, "Are you still reporting, madam, at the police station?" And she would confirm that definitely she.
Seeing a red light flashing from my instructing attorney, might I approach before and then take further instructions? Lordship would say it was as follows. It was originally Monday and Wednesday, but because we had a running trial, His Lordship ordered that it doesn't make sense. Rather, let it make it Monday and Friday. Instead of reporting Wednesday, it was alleviated to Friday, but it still remained that.
Yeah, is there a piece of paper on which these conditions are stipulated? I
No.
want to see something to that effect.
My learned colleague seems to have something.
My Lord, if I may, in terms of the charge sheet, the original of which is before me, which I can hand up, my Lord, the original bail conditions was in fact that the accused reports in person at the Midrand police station between or on every Monday and Wednesday between the hours of 6 o'clock in the morning and 6 o'clock in the evening. And then that you also hand in a passport, which I confirmed has been done, and that if she wants to leave the country, she must contact the investigating officer, my Lord, and also an indication as to the physical street address as where she would be residing, being 6156 Kempton Park. My Lord, that was the original.
Nothing said about non-interference with state witnesses.
Not specifically, my Lord. And that specific aspect, no witnesses has been mentioned in the pro forma, the original bail application, my Lord. I can hand it up to your Lordship, maybe if your Lordship wish to confirm the extent thereof.
Can you make a copy?
My Lord, may I just add that I agree with my learned colleague, the submission that the note I have is that on the 7th of September, and I believe this will be on the court record, on the 7th of September this year, the bail was amended by a Lordship that the accused only report on Monday and Friday at the Midrand police station, and that was the only condition that was then amended, and that all the previous conditions then would remain the same.
Mr. Makubela, do you wish to add any further conditions to this? You referred to the question of monitoring the accused with a bracelet and if it were possible, she would also pledge her father's property, which she is due to inherit and all that. But it's not possible at this stage because he only passed away 4 weeks ago. And
Only.
Do you wish to add, besides monitoring with a bracelet, do you wish to add any other reason?
Nothing other than to maybe highlight on the aspect that His Lordship raises to the fear or concern of witnesses. It has never been an issue throughout the bail application, and in any event after the conviction and so forth, I submit with respect that is with respect, my Lord, non-issue.
Interference with witnesses.
The state case has been closed, finished. The witnesses have testified, and she has always been outside. There's never been any history of any source of some interference or anything.
Can we hear the state argument for opposing this bail?
My Lord submitted that this application is actually in terms of section 60, subsection 11, subsection B of the Criminal Procedure Act, my Lord, which reads as follows: notwithstanding any provision of this Act, when accused is charged with an offence referred to in Schedule 5, which has been agreed indeed, my Lord, that this is the case, being murder, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that the interest of justice permit his or her release. My Lord, so clearly the onus is on the applicant in this matter, being the which satisfy this court interest of justice permit her release at this stage, my Lord. My Lord, the normal procedure is that upon conviction, an accused person, automatically the bail lapses, my Lord, and that a new application should then be brought in connection with the matter. My Lord, the only basis it appears that this application is brought, or basically two grounds the application is brought, my Lord, if I understand the application correctly, is that you wish to exercise all the remedies, my Lord, that being in respect of sentence, that further reports be obtained. As mention has been made of a psychological report, probation officer's report, my Lord. A second aspect that has been mentioned is the fact of possible medical treatment that she might require, my Lord. That is dealt with in paragraph 14. I'll deal with that. My Lord, and further that her right to consult will be made negatory if she's not granted bail. I will deal with those aspects, my Lord. First point I wish to make, my Lord, is that the situation has now changed from before the conviction of the accused. Before the conviction of the accused, obviously there are various aspects that should be taken into account when considering whether bail should be granted. Those aspects are dealt with under Section 60 of the Criminal Procedure Act, my Lord. However, once an accused is convicted, many of those aspects simply fall away, and there's now a new situation that presents itself, my Lord. It is submitted that the stage at which the criminal proceedings are is very important to determine how the court should deal with the matter. Obviously, it's before trial. That's normally where most bail applications take place. Then during the trial, there's also a possibility of bail application be brought, and then after conviction and for sentence, my Lord, for purposes of sentencing, or then a bail application for purposes of an appeal. In this matter, it's after conviction. It's submitted that different factors are relevant, my Lord. The first aspect I wish to bring, my Lord, before this court is the whole issue of the likelihood, if the accused is released at this stage, that you may undermine or jeopardize the objectives or purposes or proper functioning of the criminal justice system. The basis for that, my Lord, it is clear, and it is conceded by the accused and evidence also before this court, and it's admitted that the court might have take that into account, the proceedings, bail proceedings being sui generis, my Lord, as to what the finding of the court was, is that she did, in fact, attempted suicide shortly after the incident, my Lord. This is indicative of the type of personality of the accused, which is before this court, which the court should consider. It appears that every time there is undue emotional stress upon her, my Lord, that she struggles to deal with emotional stress. And it's admitted that her conviction yesterday, my Lord, constitute such emotional stress that might again lead to her committing suicide, my Lord. And it's admitted that if she does commit suicide while she's outside, my Lord, that would indeed jeopardize the objectives or proper functioning of the criminal justice system. Because the objectives is that the guilty person be convicted, that the convicted person be sentenced, and that the sentenced person indeed serve their sentence until completion thereof, my Lord. And it's admitted that there is, in fact, a strong possibility that if the accused is released on bail, that you might commit suicide and so jeopardize the justice system, my Lord. The other aspect, my Lord, is that
what guarantee is there that she can't commit suicide in custody?
My Lord, it's admitted that once a person is in custody, obviously the opportunities to do so are less. Certainly there is much more control over an accused person, my Lord. Normally they're locked away in cells. Normally they don't have access to any instruments or medication or whatever it might be to make it possible for them to commit suicide, my Lord. Certainly the possibility of suicide cannot be excluded in prison, but certainly it would be less possible or less easy to do so, my Lord, once a person is in custody.
You would definitely concede that there have been cases of people in custody who committed suicide while in custody.
Indeed, my lord, that possibility cannot be excluded. And that's not the argument I've stated, simply that it's...
Cut up the blankets and they make a rope out of that and they hang themselves from the windows and so forth.
Indeed, my lord, that's also a possibility. But what the other aspect is that being convicted already of a serious offence being murder, that the presumption of innocence does not apply anymore in this matter. And normally the presumption of innocence is a very strong factor that is taken into account when bail is considered prior to a conviction. In this matter, definitely it does not play a role anymore. The other aspect, my lord, is that there's a prescribed sentence applicable in respect of this matter being murder, being Schedule 5. Act 105 of 1997 prescribes a minimum sentence of 15 years imprisonment, especially, and that place an onus on the accused, my lord, basically to show exceptional circumstances why a court should not impose such a sentence. My learned colleague did refer to that. It's also dealt with in the application, my lord, that that's the reason they're asking for the postponement, is to obviously show by means of reports that there are substantial and circumstances, compelling circumstances in this matter, my lord, but none has been shown, and it's submitted that that alone also should weigh heavily on this court when considering whether bail should be granted in this matter, my lord. In dealing with the affidavit submitted on behalf of the applicant, my lord, paragraph 14 of the application, the accused refers to her physical health. It's stated that it's good, but then she makes reference that she's receiving counseling at this stage, and that she's been on and off certain tranquilizers, my lord, and that's been given to her under the supervision of a family doctor. However, the statement goes further in stating that the prison hospital seems to be ill-equipped to deal and handle my situation or illness as a trial awaiting prisoner, and then the basis for that is her previous experience before she was released on bail. My lord, the accused was only 7 days, if I recall correctly, my lord, in custody after arrest. The arrest, if I'm correct, was made on the 9th of March this year, and she was released according to the bail receipt, and bail was paid on the 16th of March, my lord. That's about 7 days that she spent in custody, and it's clear that at that stage, my lord, that the issue of her psychological state was not really an issue, my lord. This is not the submission that is made here. It is not stated while the hospital is ill-equipped to deal with this matter. It seems that the only thing she receives, my lord, is tranquilizers or medication. There's no indication that she won't receive the relevant medication if required, my lord. Same in respect of counseling, my lord. The nature and the extent of the counseling is not dealt with here, my lord. It's not stated, and it's not stated here why such counseling cannot be provided for her in a prison, my lord. And therefore it's submitted that this aspect is at best neutral for the applicant.
Are you saying that she can be provided with tranquilizers while in custody?
Yes, indeed, my lord. It is clear that in certain circumstances, if the state hospitals themselves or prison authorities themselves cannot deal with certain situations, that a prisoner may be transferred to another hospital, my lord, under police guard, and if required, then the necessary medication and or medical treatment can be given to a prisoner in a different hospital, my lord, if the prison hospital is then insufficient to deal with the situation. My lord, in respect of paragraph 20, reference is made to the imposition of further stringent conditions. Those conditions are not mentioned in the affidavit itself. However, my learned colleague referred due to certain alternatives, my Lord. However, my Lord, the possibility thereof has not been investigated or properly dealt with, my Lord, and at this stage it's admitted that it is not clear what further conditions is suggested by the applicant which should be attached if she is released on bail, my Lord.
When counsel argued that she may even get some monitoring bracelet on her, that was not suggestive of further stringent conditions on her.
Yes, indeed. It's not contained in the affidavit, my Lord. It was suggested by my learned colleague in argument now, my Lord. But it hasn't been investigated whether that would be a possibility in this present matter, my Lord. It has not been taken up with the prison authorities, and therefore cannot be stated whether that in fact is a practical solution in this specific circumstances, my Lord. My Lord, then proceeding to paragraph 21 of the statement, the submission is made by the applicant that the right to consult would be interfered with if she's incarcerated, my Lord. My Lord, certainly that cannot be true. It is clear that all prisoners that are trial awaiting, my Lord, is afforded the opportunity to consult with their legal counsel. And there's no factual basis to come to this submission, my Lord, and make this conclusion that, in fact, a right to consult would be impeded. And there's nothing that prevents counsel for the applicant, my Lord, to consult with her, or then if she needs to see other experts or probation officer, whatever situation might be, to consult her in prison, my Lord. And therefore this submission cannot be true. My Lord, with respect to Exhibit F, that is the affidavit in support of release on bail, already submitted prior to this application earlier, my Lord. My Lord, I'm not going to deal with all the aspects, but submitted that various aspects which were dealt with in that application became irrelevant basically after a conviction, my Lord. If I can simply refer.
Well, counsel for the accused argued expressly that as far as Exhibit F is concerned, he's referring to the personal particulars of the accused. That is paragraph 6 up to 10 of this document here.
Indeed, my Lord. And it's admitted that for that basis alone, it's simply relevant insofar as the personal circumstances of the applicant is before this court. My Lord, in these circumstances, it is submitted that it has not been shown that insufficient evidence has been placed before this court to show that it's in fact in the interest of justice, my Lord, that the accused be released on bail, pending the sentencing proceedings, and that on that basis then the state opposes this application.
Mr. Makubela, you have to reply because you had the duty to begin. Look, let's get to the point. The main reason why counsel for the state is opposing this application is for the 6 reasons he has given, that they don't show that it's in the interests of justice that bail should be granted. And these 6 reasons are: number 1, the likelihood of undermining the proper functioning of the justice system, which has to do with her previous suicide attempt by cutting her wrist, which you know. The second one is that the presumption of innocence does not apply anymore Now, I don't know why he refers to it. If it is irrelevant, it doesn't apply anymore. Thirdly, he refers to the prescribed sentence of 15 years in terms of Schedule 5 offences. Then, in the fourth instance, he refers to paragraph 14, which refers to the use of tranquilizers and counseling. And in the fifth instance, he refers to paragraph 20, which refers to further stringent conditions. He says, these have not been specified in Exhibit F, which was handed up. But they are just referred to obliquely. Then paragraph 21 is the last one he deals with, and he says, which deals with the right to consult. He says, there's no factual basis for this because all people in custody are given a right to consult with their counsel and their ministers and so forth. Now, you have those 6 issues to deal with in your reply. And if you deal with them successfully, each one of them, you shall have shown that it is in the interests of justice that the accused be granted bail. Right.
My Lord, I am indebted, and first of all, there is no specific requirement that any specific aspect should enjoy more preference than any other. The call to the Honorable Court is to take into account all factors accumulatively and, of course, individual, but the cumulative effect thereof, and not to specifically take them in piecemeal. Be that as it may, on the first concern raised by the state, I submit that even on the history and previous conduct of the applicant and even during the trial, there's no reason to believe that the proper functioning of the justice system will in any way and would have been interfered with. The trial has run its course, and if she's still outside sorting out things and or getting her mitigating factors into order while outside, how does that affect the proper functioning of justice? It would seem on your Lordship's finding that at least we have reached the afternoon of the course of justice. We just only waiting for one aspect, and that aspect can only be appropriately dealt with when she has an opportunity to deal with all relevant aspects. And my Lord, I submit that the process also towards determining proper sanction should also remain fair, despite being an anticipation of some penal sanction. But the route of getting there overall and substantively should remain fair. And I submit that in the circumstances, it would be in the interest of justice that she be afforded to deal with those, because there is no reason why she should be inhabited. It would seem she's better off dealing with those aspects outside the confines of prison than inside, where she'll have time and access to the various experts and or consultations rather than in prison. And it is fanciful with respect to state uncategorically that the prison environment is so ideal. And I submit that if there is a reasonable possibility that it will serve the interest of justice, that the accused or applicant deals with the aspect outside the confines of a prison, that should be a consideration that the Honorable Court ought to take favorably to weigh in favor of the applicant. As for the second issue regarding suicide, my Lord, the applicant has submitted, and there is nothing to contradict that under oath, except by way of speculation, that there is a reasonable possibility that she might entertain possible suicide. We have submitted, and it is not contradicted, that she's under treatment. She's seeing psychologists, she's seeing some therapists, and she's seeing a family doctor. And in the environment of prison before sentence, where we need to address those aspects so that we should lay bare all full facts before court, it would be better off to allow her to deal with that whilst dealing with this situation of an emotional state, that the precarious state that is being attended to. And in fact, since her release on bail or anything, after even the tragic passing away of his father, she seems to be dealing with the situation reasonably well, to the extent that the notion of a possible suicide is more speculation than a reality on the face of the facts that are apparent with the history taken into account, and the assertion that the applicant has placed before you, and also that indeed the events of the day that led to the conviction today were very tragic, and she has had the attendance of the professionals to deal with it, and they are dealing with it. And the request is that, if it may please the court, give her the opportunity with respect, so that you should have adequate information in order to determine what an appropriate sanction should be in the circumstances. And I do not think that the granting her that would in any way inhibit the course of justice or the functioning of justice. And I submit that it is in fact in the interest of justice that you get, with respect, all those aspects covered. As for the presumption of innocence, we have submitted in the affidavit that the presumption of innocence does not help her much, because she has been convicted. The only way where I really submit that it would have been is pre-conviction, and that has been considered, and it is neither here nor there, and one cannot only harp on that at the expense of the other overriding factors that we have indicated individually and accumulatively to the Honorable Court. As for the pending sanction of imprisonment, we have submitted that it has always been there. She has always known that if things go wrong or arrive for her, that is a real possibility. But she has never attempted, and there is no history that she attempted to run away. And I submit that the court should carefully weigh the likelihood of the accused considering it worthwhile to abscond rather than to face what is coming, no matter what the circumstances are. She's got more to lose by being a fugitive from the law rather than coming to court, gets her medicines worth, after which she's even aware that she's got other remedies subsequent to whatever the court might decide. Amongst others, she's aware that she's got the right of appeal. She is aware of all those remedies, so that there is no reason whatsoever to be dissuaded by the possibility of that. But if your lordship is of the view that that is in fact a possible incentive for her to do so, as already submitted, there are conditions that can militate that particular apprehension, and I will address the court. As for paragraph 14 and the issue of tranquilizers and doctors, at the end of it all, it is treatment. She is under various experts that are dealing with her jointly, and whose joint reports we will require for purposes of mitigation. And I submit that she's better off outside the confines. And the doctors, the family doctor, decide as and when she should be, after the consultations that she has with them from time to time, in conjunction with the psychologists that they are seeing, that is it time for it or time for it, taking into account her history of a suicide, as it were. And I submit that those doctors should rather be the one that continue with that treatment and be able to come and give the court a comprehensive report which is not disjointed by possibly other intervening reports from prison authorities. As it has become apparent, after she was incarcerated pre-trial for bail application, she was seen by some doctor at the prison. She was seen by the doctors from Alexander Clinic. There has never been any record forthwith. And we are submitting that that can be at least averted, because she has at least shown an inclination of keeping record and making available to whatever extent that relates to her bodily and emotional well-being, which is relevant for whatever purposes it might be required for court. And to this extent, I submit that the apprehension number 4 shouldn't also hold. My Lord, the issue of not dealing with a stringent condition is specifically not to tie the court's hands insofar as discretion. We have submitted that we will allow ourselves to be guided by His Lordship's wisdom and guidance as to what in these specific circumstances would be appropriate stringent conditions. And we've made a recommendation of from the doc, namely that amongst others, but it is submitted that this is solely done in order not to subvert His Lordship's discretion, because we submit that His Lordship is more suited to can exercise its judicial discretion and wisdom more favorably, at least if I can speak for myself, than I can make out with respect. And any shortfall to that extent can adequately be supplemented by His Lordship's wisdom and intervention, to the extent that I submit that with those conditions it will be in the interest of justice that she should be allowed. And it is my last submission that yes, indeed, conditions of prisons are not, they do provide consultations and so forth, but I am submitting to His Lordship that if there is a possibility and a good reason to allow her to do outside the confines of prison, why not? If it does not interfere with the interest of justice. And in what extent does it interfere with the interest of justice that she be allowed to deal with her legal woes outside the confines of prisons, where it will actually be more ideal to adequately deal with them with his legal team as well as his medical team for the benefit of His Lordship, insofar as what is relevant for the for the sanction.
It shouldn't be for the benefit of His Lordship. It should be for the benefit of the interests of justice.
Yes, isn't it? It is your Lordship that must determine whether, in the light of that factor, it is in the interest of justice.
I can only weigh and consider arguments and contentions from both sides. But if you raise a question, for example, if you were, I would appreciate it if you were to apply your mind to other factors which you think would further the interests of justice, especially, to ensure that on the 9th and the 10th she is here for sentencing, and she does play her part as far as the interests of justice are concerned.
Precisely, my Lord, and I'm submitting with respect that to that extent, His Lordship should take into account her previous conduct. It is non-indicative of or to the contrary. And I have also submitted that there is no reason to believe that she won't attend. And it is not contradicted by any evidence, whether oral evidence under oath or otherwise, as against the weight of her evidence on affidavit that I will stand trial. I believe in the judicial system of South Africa, and I believe in exercising all my recourses in terms of the law, whatever penultimate adversity might be looming.
It is all well and good to take her previous conduct into consideration, that she complied fully with her bail conditions and so forth and so forth. But the situation has changed since yesterday.
And she has admitted to that.
Yeah.
It is not denied. It's common cause. And she has deliberately stated that, and it has been specifically addressed. And we are saying, in the light of the change, it would be within His Lordship's right to at least improve on the stringent conditions.
I want you to give me a further conditions
Your Lordship, I'm
apart from
suggesting that even if it means house arrest under specific circumstances, the applicant is prepared in order to show her willingness, as long as the house arrest will not interfere with the times at which she's going for medical reasons and or consultations and so forth, to the extent that His Lordship might determine to be appropriate. And it is this aspect that I had submitted, that I did not want to tie His Lordship's hand, but we will be guided by His Lordship's wisdom in this regard.
what else?
I have nothing. Might I just take some?
Paragraph 21, the right to consult. The essence of Mr. Skirter's argument is that nothing prevents counsel to consult with the accused in custody.
We have admitted to that, and we've also submitted that if there is no reason to rather have her do so outside confines of prison, why not? And we are submitting with respect that, my Lord, one cannot be restricted by this one specific aspect when you have an applicant that says to His Lordship, I've just lost my dad, amongst others, and still wish to do the traditional cleansing ceremonies, amongst others. I still have to attend my therapy and I still have to see my psychologist in order to prepare reports. I am prepared to report. I am prepared to wear a bracelet to show that I am not going to disappear into thin air. That is all, my Lord.
The cleansing ceremony you're talking about, where is it going to occur?
At Kempton Park, her parental home, but she is guided by her uncles in this regard, the elders that went to slaughter, but it is within the next short space of time. It is going to be dependent also.
If the uncles come from the Eastern Cape and they say it's got to be done in the Eastern Cape, what then?
We will give them legal advice that that cannot be, it must be done as soon as possible because she's got legal rules that take precedence. We understand that traditionally and constitutionally you have a right to practice your beliefs and so forth, but please, we have had the indulgence of the court to deal with. We can't simply take advantage and go back to the court and come with excuses. This needs to be dealt with decisively.
Yeah. I don't get blessed by counsel. Don't. You're right. I have listened to argument from both sides, and I am convinced that over and above the bail conditions which were set earlier, if a few other conditions could be added to these conditions, then she deserves all the chance and all the privileges to advance the interests of justice by coming to court on the 9th and the 10th of March 2016. So I am inclined to grant her bail. This is what I'm saying. And I'm saying that this bail must have conditions, and these conditions are the same conditions that are specified in the bail which she was given earlier. And to these conditions we add a few more in the interests of justice. Firstly, she was out on 10,000 rand bail, and I think that if, with the available means to her, a 5,000 rand could be added to this 10,000 rand, it becomes 15,000 rand now. That would be sufficient for purposes of making her to attend court for sentencing on the dates mentioned. Secondly, that she is not allowed, she mustn't be allowed to leave her Kempton Park residential address without the permission of the investigating officer. It can happen that for purposes of the cleansing ceremony, her uncles come from far and wide and they want to take her away to go and perform whatever they want to do to cleanse her, and that should be regulated. They must understand that she cannot leave her residential address in Kempton Park without the permission of without informing the investigating officer. Without informing the investigating officer. I shall not go as far as to keep her under house arrest. I don't think that is necessary. The mere fact that she's got to report her departure from the residential residence, from her residential residence to the investigating officer, that is sufficient. She shouldn't be under house arrest. But I'm tempted to say, to ensure that she also participates in furthering the interests of justice, she must be willing, ready, and able to have a monitoring bracelet on her so as to make sure that she does attend her sentencing day in court on the 9th and 10th of March 2016. So she must be provided with a monitoring tag, a monitoring bracelet. So I have mentioned 3 further conditions: the extra 5,000 rand, and the fact that she must not leave her residential address without the permission of the investigating officer or without informing the investigating officer, and then she must use a monitoring tag to ensure that she is definitely coming for sentencing on those days.
As it pleases the court, my lord.
Right. Madam, you can rise. I hope you feel comfortable enough now that You were allowed to change yesterday's clothes into today's clothes down there. And I want to believe that you understand the conditions, the 3 further conditions which I've added to your initial conditions. The question of reporting to the Midrand police station still has to be done on Mondays and Fridays before 6 o'clock. Ne? Not Wednesday, but Monday and Fridays, right? Yeah. So you are hereby granted bail of 15,000 rand, and with those conditions attached to your bail. Ne? And we'll see you after Christmas. May you enjoy a Merry Christmas and a prosperous New Year. And we'll see you in March on the 9th and 10th of March. Ne? All right. That is the position. Any further representations?
Nothing from Mr.
Nothing.
I was inclined to wish you a Merry Christmas.
No, I don't. I don't need that from council. I don't need that from council. Right. The court is going to adjourn. We didn't even go for tea, but we are now going to adjourn, and the accused has been given bail, and a postponement date has been given for sentencing. So the 2 things I mentioned when I got here have been dealt with. Court adjourns.
That's what I want to ask you. What is the procedure?
I'm not sure what the procedure. I just what I
want to catch the one with something.